All right. Hello, everyone. This is Kurt Verone, and welcome to another edition of Fire Law Roundup, this time for August 22nd of 2022, which is actually tomorrow. We again are going a little bit ahead of ourselves, but we both have busy schedules, so it works out that we're doing it a Sunday night. Maybe Sunday night's better, Brad. I don't know. What do you think?
Who knows? People may like it. Look, they can watch it whenever, right? Once they're recorded, watch it whenever you want.
Yeah. Yeah. Well, the system sends them out a notice, as soon as we go live. So there's no real way that I know of to send out a notice ahead of time that we're going to be late this week or early next week or whatever it's going to be. So at any rate,
viewers, you tell us what you want.
Yeah, that's right. Let us know. So, Brad, I know last week was kind of a crazy week.
Great week. This is pretty good. Not as crazy, but pretty good. So let's start with Miami. And this is more of a discussion point than a legal case, right? It might become a legal case if I had a guess. And by the way, before we say anything here, do not shoot me for my comments. I know what I'm going to react to this. Do not. Well, I shouldn't say do not shoot me. That's a really bad phrase for this one. Do not get mad at me for my comments I'm about to make. So here we have a Miami firefighter. He was terminated because he made comments in a group chat, right? And I think it's just a group chat. It's not about his work, but so he's a firefighter. He makes comments in a group chat about the murder of a Miami-Dade police officer. Now, look, obviously, horrible, right? I mean, horrible thing, but we're on the legal side, not on the moral side right now. Mm-hmm. So he's a 9-year veteran of the officer who was killed. I'm sorry, the firefighter who was fired was a 9-year veteran of the fire department. He was fired one day after he posted the following comment. I'm going to read part of it, or I'll read all of it because it matters. Now, before I read it, I will. And here's what I want people to think of. Remember, the first question we're going to ask here, at least I'm going to ask for this under a Pickering test, and that's to determine whether this comment is protected by First Amendment rights. I suggest it is. I can't wait to hear what Kurt says. Don't answer yet. But remember, one of the tests we're going to look at is his comment speaking as a employee, and the second part is, or is he speaking as a citizen, and is he speaking on a matter of public concern? So keep those in mind and listen to what he says. And remember, he's a firefighter, right? Not a police officer, but nonetheless, he's a Miami firefighter speaking about a Miami-Dade police officer who's killed. So here's what it is. He posts, "Who cares? Another dead cop, probably against gun control. They didn't give a expletive. When kids were dying in that school shooting, they stood outside. Cops exist." Again, this is what he says, not what I'm saying. "Cops exist for the government to exercise its monopoly on violence. They want the whole world to stop when one of theirs goes down. How many idiots I had to transport with honor guard their dead bodies from coronavirus because they were too stupid to wear masks or get vaccinated. All cops are good for is protecting the rich property owners and the status quo. Everything else is a farce. Expletive, the police."
Could have been written by Vladimir Putin.
Yeah, probably. I mean, look, holy shit, who would say this? Yeah. But the question for this is not yet a formal question, but I'm guessing this guy may, find a lawyer and say First Amendment. So here's my first question. There's a couple of key phrases in here, right? One, was he speaking as a member of the public, or was he speaking as a firefighter? And Kurt, I want to throw this out to you, that specific question, and I want to focus us on a phrase, right? How many idiots I had to transport with honor guard? Let's assume for the moment the honor guard's part of the fire department. Yeah. So, Kurt, what do you think? How is he speaking?
I think it's a stretch. I think to really determine whether or not someone spoke as a private citizen or as a public official, I think you got to look at the nature of their social media presence. Do they have pictures of themselves in uniform? Do they use the fire department's name? Do they have their rank and title and a lot of information in their social media presence.
Does their
about
job
that.
include speaking on behalf of the fire department?
Yeah, all of those things. I think those are more important. It reminds me of there was a case out of Columbia, South Carolina, where a captain was on duty the night of the Black Lives Matter protests where they're shutting down the highways. And he said that on my way home, I'm going to run people over. You know, fine. We know you must have a job, but you know, you didn't say I'm with the Columbia Fire Department. You know, it's not like you identified that. So I think it's a stretch, but if you couple that with some other things that are on his social media platform, and again, I'm not even sure the news that I saw wasn't real specific about what social media platform he was using. But if he was using Facebook or whatever, if he's got a lot of pictures or Instagram, whatever it is, if he's got a lot of other things going on there, you know, it may be the thing that tips the scale.
But most likely you're saying, just so our viewers understand, he's probably speaking as a private citizen, not as an employee.
Yeah, let me put it this way. I think we got plenty of rope to hang them on other things we don't need to. Remember, there's 3 tests, there's 3 parts here, and one of which is, did you do it as a private citizen? So even if we give him the benefit of the doubt on that one, and even if we give him the benefit of the doubt on the second one, I think he's got some pretty serious issues on the third one.
And explain that. So for the viewers again, so, okay, fine. Maybe he's speaking as a private citizen. I think he is. I agree with you. Yeah. He's speaking as on a matter of public concern. And yeah. I kind of do think so, because he's talking about the school shooting, right? Where the cops did wait outside for a while. So he's obviously speaking about that. One
of the hardest things that it is very difficult for all of us is when you disagree with someone to recognize or acknowledge that it is still a matter of public concern. Okay. There's a tendency that if I think in a certain way, then anyone who disagrees with me is expressing a wrong opinion, and therefore they don't have a right to express it. And I think what you have to do is you have to disassociate from what the person is saying and say, is the topic that's being discussed a matter of public concern? And there's a lot in what he said. And I made a joke about Vladimir Putin. It sounds almost like a communist kind of that the police are for the rich, the police are to oppress people. You know, it's almost like, you know, really, that's what the police are about. I mean, you know, but there's a lot in there. There's a lot in there. But I think my tendency is to give them the benefit of the doubt on the matter of public concern when there's some colorable argument that can be made that there is in fact an argument. And you know, he's making social, he's making racial allegations of oppression, of what the police are about. So you know, separate whether you believe it or not. I think it is a matter of public concern. I disagree with it, that's fine, but I think it is a matter of public concern. So I give him the benefit of the doubt. You know, he did it as a private citizen. It is a matter of public concern. Now it's going to be time to pay the piper when it comes to the Pickering balancing test.
Okay, and go on with that.
All right. Well, the Pickering balancing test is when you have to balance the interests of the employee speaking their mind versus the interests of the employer in having restrictions on that type of speech. And I think there's just so many ways. I mean, he's suggesting to other people that it's okay to kill cops, that it's actually a good thing to kill cops, that it's good to see police officers die, that we shouldn't be recognizing officers who die in the line of duty. So that's sort of number one. He's not saying go kill cops. Okay, I think if he's saying go kill cops,
violence, right? Yeah,
very clearly, if he's saying go kill cops, but he's suggesting that it's okay. So that's factor number one. Okay, he's also creating divisiveness between police and fire, and he's suggesting that firefighters. Well, maybe a better way to characterize it is you can't square support for law enforcement or lack of support from law enforcement with being a firefighter. Okay. We're both involved in protective service, and this type of rhetoric, political rhetoric, is the type that can cause friction between the two organizations, distrust between the two organizations that have to be able to work together. Okay. And so that would be my concern here, that it creates the kind of divisiveness that can create friction between police and fire, that from a leadership perspective, we can't have that kind of friction. And if it was a police officer saying the same thing about firefighters, I'd feel the same way, that we can't have that kind of friction between police and fire.
So I got to tell you, and I want to then focus on one more interesting part of this. Now, I personally disagree. One,
Okay,
like
that's cool. That's cool.
the
Yeah.
comment sickens me, right? Like all of us. So it sickens me. But I got to say, I think he's really speaking on what he thinks is the institutional bias. I can't say race, because I don't know if it's race, but it's certainly class bias. He perceives that at least there, the police are not treating everyone fairly, which is certainly a matter of public concern. And, look, I don't like the who cares part, who cares another dead cop. But if you took all of that out, right, if you just took those couple lines out, really speaking about a class bias, and bias is a matter of public concern. And I don't know that I think this should not be protected. I think it's disgusting, but who cares? That's not the point of the First Amendment, right? So I don't know. I don't know that I agree, but who knows? But let me ask you this. What about the fact that it's in a group chat? This is not on Facebook. This is a group chat between, I don't know, 2 people, 20 people, who knows, right? But it's a group chat. It's not posted for everybody to see. These are people participating in a conversation. So if I stood in a room with a group of my friends and said this, why shouldn't that be protected? Why should I be fired because I express my view to my friends?
Mm-hmm.
I don't think his termination would stand.
Well, I think the difference is that when you say things in social media, it's not like saying things to your friends, because it can be spread. It's like publishing something in the newspaper, or stating something. For example, it's like sending someone a letter. If you say something in person, like if you and I have a personal conversation, unless you're recording it, or I'm recording it, or we've given permission for someone else to record it, there's no record of it. Okay. But when I send you a letter, I have no expectation that you're not going to share that letter with someone else. That's not reasonable. If I send you a letter, you have every right. And depending on what's in that letter, you could send the letter to the Rhode Island Supreme Court and have me sanctioned. You could take it to the police, and if there was something that I said in there that was criminal, you could have me charged criminally. So there's not an expectation of privacy that may exist within a conversation that exists when you send someone a letter. And I think when you post something in social media, it's in a similar vein, that you don't have that expectation of privacy when you say something in person.
But in group chats, like text me or chat me, things like that, you have to be invited into the chat to see it.
Yeah. So
would that change your opinion, knowing that these are people they specifically bring into the chat and allow into the chat?
No, it'd be like the same as if you and I had a way of sending each other letters in invisible ink, and only you could see it. But at the end of the day, you can still find a way to show the invisible ink to someone else. I put it in writing. That's the most important thing, that I chose to put it in writing. I chose that method of communication. I could have whispered it in your ear so no one would have heard it. I chose to put it in writing. And you don't know where, once you do that, you don't know where it's going to go. I can say, well, I thought Brad would keep it to himself, but and I think that's one of the dilemmas that we have with the technology. He may not have expected it to go beyond where it went.
And it did. Somebody showed it to somebody, right? There's no question.
Yeah, no, but I think it raises an interesting thing. What if you and I, let's say you taught at a college in Syracuse, I teach at Providence College, and the same exact words were said in a classroom.
But as an opinion or as part of
Yeah,
the
we're
lesson?
having a class discussion.
Well, why would it be different here?
I see a little difference there, because here's where I see a little difference. It's called academic freedom. Where in the environment of a classroom, we should be free to say things and have debates and have discussions without having to worry about the consequences of it. Short of threatening, you don't want to threaten the professor. Definitely don't threaten the professor.
Yeah, no.
That's not good for either of us. So, but the point being that I think that academic freedom in the confines of education would make for a healthy debate. Like, what if he was on a debate team and he made the same statements as part of a debate? Not that he necessarily believed it, but that his responsibility was to make the argument.
Look, I just read it back, right? What if somebody clips me reading it back and sends it out? Which is why I was very nervous about actually reading it. That I as lawyers, we know you need to see the whole facts, right?
Yeah. Absolutely.
What was the comment before it? What was discussion before it? Not right. So we saw he responded to something that prompted him to say, who cares? Right. Maybe they were having a whole discussion about something else. And somebody said, oh, well, what about the cop who just got shot? And he's like, who cares? There are bigger things going on. Right now, not that I would ever say that, or agree with it, but there's more to it. I don't know. I think it should be protected First Amendment speech. It sickens me. But as Alan Dershowitz says, the question of how much you believe in the Constitution, right, is how much will you tolerate of those things that will sicken you?
Well, I mean, if he was my neighbor, I wouldn't take any repercussions against him.
Yeah, I might shoot him in the leg.
No. I mean, that's fine. That's you're entitled to your opinion, okay? But when you work for me, if my paralegal said that, and half of my clients were police officers, and he's going to alienate half of my clients, I can't have you alienating my clients. If my brother's a police officer, my son's a police officer, okay? You can't come to Christmas. I mean, it's just going to create too much friction. And I think that's the problem when you make those kinds of statements. And
that's the question, though. Do you always wear the hat of being a firefighter, right? Do you always wear this hat? Am I ever Brad Pinsky without the chief thing, right? Or do you sometimes?
You're going for a fit test, Pinsky. Let's see. You better get the Vaseline out.
So do you always wear that hat? Are you look in a business? You always represent the business.
Yeah.
Right. I mean, you always do. So does a firefighter always represent the fire department, even off duty?
Yeah, fair comment. But on the other hand, we go back to the Locurdo versus Giuliani case, and where the FDNY firefighters and NYPD police officer put the racist float in the parade. Even if you don't associate this with your fire department or with your employer, and even if it is a matter of public concern, there's a limit when you cause actual harm or disruption to the mission and function of your employer. You lose the First Amendment right that you might otherwise have. So that's what I mean. My neighbor, fine. My neighbor wants to say that. Somebody else in public wants to say that. That's their right. And I don't think any of us should limit their ability to say that. But there's consequences if you work for me and you're going to alienate my clients, or you're going to alienate my family or others that we're going to have to work with on a daily basis. I can't have you in my employ. I think that's where I'm at.
It will be very interesting. By the way, just for me, if the person who said this is watching, do not call me to represent you. I disagree vehemently with what you said, and I would never say it. So you may or may not have the right to say it, honestly, but not in my world.
The whole class, what kills me about folks that say, and I've got some relatives that might be prone to say something similar, by the way. But yeah, I know it. And not so much on the police thing, but more on the class, like,
yeah.
but does a firefighter who's making 100 grand a year, 80, 90, whatever, 100 grand a year, realize that to a large majority of people, that they are the wealthy, that they are part of the wealthy, and he's probably thinking here, say, oh, I'm talking about somebody who makes $10 million a year. No, to many people, you are the wealthy.
Right.
And the police are protecting you. It's amazing. They just parrot what they hear wherever on TV or social media and never really say, well, wait a minute. I could be talking about myself here. The police.
Man, if that guy died line of duty in a fire, what is somebody going to say? Who cares? Another dead fireman. All you do is protect the rich. Come on.
Yeah.
So okay, let's get out of Miami. But let's stay with the M's. Let's go to Massachusetts. This is really good news. This is exciting. It's so as viewers may know, in Massachusetts and Syracuse, New York, a number of cities, I don't know how many, but at least 3, have had consent decrees where they found, historically, this one goes back to 1972, but where they found that the hiring practices of a municipal fire department, police department, et cetera, were not consistent with the percentage of population in the community. In other words, the community may have 30% African-American, but the fire department only has 5%. And they're saying that doesn't make sense. Clearly something's out of line. You should be hiring to the same percentage. So back in 1972, they put in these quotas, racial quotas, really interesting way on how they do it. You create 2 groups, A and B, and they say, okay, we're going to choose somebody from the white people group A. And, for every 3 that we hire on the white people group, you need at least 1 in the African-American group. In any event, the court said that, look, they've reached their goal and we don't need the consent decree and it will go away in 2024. So kudos. And the reason they're doing that, if anybody is sitting saying, well, why would you get away from it? This has Roe v. Wade consequences. Listen to the language. I know people are saying Roe v. Wade. Why are you talking about Roe v. Wade? Yeah, and the more recent case, but listen to the language. So what the federal court says is, listen, a race-conscious remedy, which is what this is, must survive strict scrutiny. In other words, it must be justified by a strong state interest and narrowly tailored to achieve that interest. And the federal government should stay out of it once it's solved. So, and they talk about, this is where my point is about Roe and states' rights. The court says an intrusion by a federal court into the affairs of local government should be kept to bare minimum and not be allowed to continue after a violation has been abated and its pernicious effects have been cured. In other words, federal government, says the federal court, stay out of it, let the local government deal with it. And that may sound to some like the federalism, right? Federal versus state, Roe v. Wade, the whole abortion issue. So that's why I bring it out. It's the federal tests recognize will lay a heavy hand to solve a local issue, but once the local issue is solved, the federal government needs to get out. I don't know that our current federal government would believe this, but nonetheless, and that was good.
Well, I think it was 50 years, and that's a long time for a consent decree. There's no maximum limit on them. And this one actually got extended a little bit because there was a couple of little hiccups along the way. Their 3-for-1 hiring actually ended up because of some population shifts.
Became 1-to-1
hiring actually worked against the minorities, and so they had to make some adjustments there. But some of the cities, the bigger cities like Boston, they were 1-for-1 hiring. They weren't 3-for-1. They were 1-for-1 hiring. And then most of the other cities were 3-for-1 hiring. So at any rate, the ruling now, the NAACP was the plaintiff in the case, and they actually wanted it. Let me just see. I think they wanted it extended for another 15 years, I think. or they wanted to extend it until 2040. I think.
Yeah, and that was where the response of, listen, the federal court needs to get out. The federal government needs to get out once the issue isn't an issue anymore.
That's right. The NAACP sought to extend it for another 18 years. So it's 2022 now. They wanted it to go until 20. Is that my math right there? Yeah, 2040. And the court said no. 50 years is enough. It's been in place 50 years. We don't need to go to 70 years.
Successfully in place, right? Not just because it's been in place, because it's been successful and has cured the issue.
Yeah, I at least percentage wise, and I think over the years, our understanding of the proper way to test and evaluate and score those processes has improved to the point where there's enough processes out there that don't have any sort of discriminatory effect, so that if you put folks in a room, everyone's going to be on an even keel, that we're not going to see a lopsided score with white scoring very high and minority scoring low. So I think that our understanding of how to test and how to evaluate people is much better than it was certainly 50 years ago, even 20 or 30 years ago.
But you can bet the NAACP or other watchdog groups will be watching to make sure that the cities stay
as they should.
As they should.
As they should.
They should.
As
Absolutely.
They should.
Okay. Let's go to, the opposite of race, interestingly, or the opposite of race issue is a issue that's not based on race. So let's go to Hartford, Connecticut. And here the city was successful defending a race discrimination allegation lawsuit. And the reason they were successful is really important for the viewers, because there was all sorts of claims by the firefighter that I was denied leave and I was drug tested and I was treated differently than, than white people in the same position. And the court looked at it and really said, you know what? You haven't linked your race. And there's two reasons I think he lost, in my opinion. One, the court says you haven't linked your race to the reasons that you were treated this way. In fact, it seemed like you were a problem. Which is, I think, what the court finds. There is actually a legitimate reason. That's the second part. There's a legitimate reason why these actions were taken against you. They weren't based on race, but nonetheless, he didn't even prove that race was a factor. And they go through his, 10 some odd allegations of when he was treated differently and, and not in a good way, I guess, not promoted, not given leave, all these things, drug tested. But the court just says, you haven't shown that race was a factor. And in fact, it seems like they had a good reason to do it. And so, for people out there who think, oh, I'm just going to claim the race card, religion card, any card, right? Any protected class card, you better be able to prove that the reason they're doing something, one, is based on your protected class, and two, that there's not a legitimate reason they're doing this, which has nothing to do with your protected class.
Yeah.
So
I think I covered him his earlier allegations in the same case when they were dismissed, and the court kind of gave him a second shot at amending his complaint here, but essentially the facts that were alleged were not sufficient. They were, I think, I want to find the right way the court phrased it, but they were more about, personality conflicts and the types of things that happen in the workplace as opposed to race discrimination. So you can't find the exact language right there.
Well, yeah, and he says he couldn't prove a discernible connection to his race, and
right.
You have to. And normally the way they would do that, by the way, is say, well, okay, we have one black person who was treated negatively. We have 10 white people who did the same thing, but they weren't treated like the black person, right? And so that would be a way to show it. He couldn't even do that. So had he done that, the burden then would have shifted right back to the employer to prove that there was a legitimate reason that was free in any way of his protected class, in this case, race.
Here's one of the quotes. The law does not blindly ascribe to race all personal conflicts between individuals of different races, because to do so would turn the workplace into a litigious cauldron of racial suspicion. Okay.
Yeah.
So interesting quote there.
I phrase it differently, and I've always said this, you know, being a jerk is not a protected class, and we could fire you because you're a jerk, right?
Yeah.
You may be a black jerk, gay jerk, Jewish jerk, whatever jerk, or woman jerk, right? But you're just a jerk, and that's the reason we're firing you. So that's
Well,
not.
I don't know if
class.
that's the case with this particular guy.
I'm not saying that. I'm just saying there's
right. No, I agree with you. But the court, you know, the court is essentially saying that if you're going to say that someone discriminated against you because they yelled at you, you've got to show somehow that it was racial and not for some other reason. You know, not because, you know, for example, you were about to run somebody over by backing up without having a spotter and they yelled at you. They yelled at you because you were backing up without a spotter, not because, because of your race or your religion. Or
unless they scream, hey, you effing whatever, right? Slurs, that might do it.
Right. Or someone who was not in your protected class did the exact same thing and didn't get yelled at. So that's right. And I think that's the point that the court was trying to encourage the person, the firefighter, to point out, but it never materialized.
Yeah. Oh, okay. I love this one because I don't understand it, and I did a little research on this. So we're going to go to Ohio, and here there is a patient who is having respiratory issues. He was asthmatic. The fire department gets there, and they told him allegedly, this is all allegedly, right? This is a lawsuit, not a court finding. So allegedly, the patient or the patient's representative, because the patient couldn't speak, told him that he's asthmatic, he uses inhaler, and it didn't work. They give him, I think, 3 rounds of Narcan, and somehow he becomes a quadriplegic. So I have 2 questions because I couldn't discern it, and I'll kind of answer my questions a little bit. But first is, were they claiming, one, that Narcan causes quadriplegia?
No, I don't think
2,
so.
I don't think so. In fact, let me start on that. I looked up the side effects of Narcan because I never heard of that, and I've never heard that respiratory distress is a contraindication to giving heroin. And frankly, I've done it so many times I can't count. That I don't know. But I looked it up anyway, to be fair, and no, becoming quadriplegic or any spinal or brain issues are not a side effect of Narcan. In fact, Narcan has some side effects, but usually only when you are on heroin. In any event, so the second reason, I'm presuming, is the real reason they sued, because I think they assume that they delayed care, right? And that led to maybe some brain death and thus his paralysis. And the answer will be very simple on a win or lose of this lawsuit, at least a win. Did you follow in order the protocol? If you follow the protocol, I don't think there's any liability. Mm-hmm. You might argue the protocol is bad, but as to the fire department who followed the protocol, assuming they did, and I don't know they did, but they don't seem to say that they didn't follow the protocol. Maybe the lawyer doesn't know or whatever, but if you follow the protocol, they're off the hook, right? They didn't use any judgment. They just said difficulty breathing. Here's what we do. On the other hand, when you're told it's asthmatic, I don't want to speak as, as a caregiver. I'll stay on with a lawyer hat, but, you can't really give albuterol necessarily. You can bag them in certain ways. I don't know what their protocols are, but, it was preventative, right? It's like you take someone's blood for cardiac arrest. Why are you testing their blood for cardiac arrest? Because that may be the cause, right? So here they're trying to figure out, right, why is the person not breathing? So they tested for heroin. Now, maybe they're so offended that they're testing for, or they're trying to treat heroin, but there's so much that's missing. We don't know what they did before the Narcan administration, right? We don't know what the protocols say. So all we're doing is saying this is a lawsuit. If it was me, I'd want to see the paperwork. I'd want to see the protocols. I hope it's a very good write-up for the sake of the department and the paramedics and all such. But, it's an interesting lawsuit. But it's basically, I assume what they're saying is you delayed care, and your proof of delaying care is why were you giving Narcan? But I'm pretty sure they're going to have Narcan in their policies for unexplained respiratory arrest.
Right. Unexplained unconsciousness. Yeah. And I think so. And well, a couple of things kind of jump out at me. And as you were speaking, the one that first came to mind was immunity, that in most states, EMS and firefighters will have immunity when they're providing emergency medical services, but it's only for negligence. So the question would be, if you mistakenly diagnose an asthma patient as being an overdose patient and administer, basically you follow the wrong protocol, that's more in the nature of negligence.
Right.
And even if somebody's speaking to you there, you know, a lot of times we get people, well-intentioned people, but they're kind of giving us information that's leading us in the wrong direction. And sometimes
especially parents.
Yeah,
my kids would never do drugs.
Yeah. So I think there's a potential here for some immunity protection that's going to go in the firefighters' favor. Okay. You know, and now if it was beyond negligence, was gross negligence or recklessness, then that's a different story. So that's sort of number one. The second one is, you know, people are not sophisticated. Civilians are not sophisticated. When they call 911, whoever shows up are paramedics and, you know, super paramedics that are going to save somebody's life. Okay. Could have been an engine company that didn't have ALS gear, but they did have Narcan. And so the first engine starts with Narcan, then the ambulance comes in later. And so again, the complaint is allegations. Obviously the people who filed the complaint don't have a great deal of background in this. Maybe the attorneys don't even know what questions to ask in terms of putting the complaint together. But I can also see this exact fact pattern being where an engine company gets there. They've got Narcan, but they don't have, you know, they don't have anything beyond that. And so, well, you know what? It certainly doesn't hurt them, I don't think, to give them Narcan if you don't have albuterol or some of the other medications, oxygen, some other things there. But on the other hand, if you do have all that other stuff and there was a delay, then maybe there is that causation piece. So again, they'll have to sort that all out through discovery and through the trial process.
Yeah, tough road to hoe. And you know, okay, let's end nothing hugely exciting, but certainly interesting. Wisconsin City is going to pay 5 firefighters. They eliminated their positions 7 years ago, I think, in July of 15. They eliminated the 5 firefighter positions to go to a paid-on-call system, and they sued and they won under state law. So in 19, actually, they settled here, but the Minnesota Supreme Court in 2019 concluded that the city did violate the state law. They sent the case back to trial for further proceedings, further questions, and then the county district court found again in favor of the firefighters, I think without trial because it was summary judgment, and they concluded that the firefighters were entitled to reinstatement and an award on damages. Here, then, they settled. The firefighters said, okay, fine, we don't want reinstatement. Frankly, they've probably been working other jobs. I don't know that. I really don't. But
we covered one a couple of weeks ago where the guy got laid off and he ended up making more, probably swinging a hammer. He made more as a carpenter than he did as a firefighter. And
they still had to pay him.
Yeah, they still had to pay it, right?
Yeah. So, and I think that would be this too, as well. But the firefighters agreed not to be reinstated as part of the settlement, which is fine. Why would they want to be reinstated, you know, after all this time or not? Who knows? But they probably have other jobs. But I don't know. We'd love to hear from you if you do, if you're one of the firefighters. But in any event, so the part that I found most interesting about this, it has nothing to do with this case. It took 7 years, and I got to tell you, when people are talking about suing, I mean, look, we just had a trial. My wife just had a trial on my wife's motorcycle accident that happened 7 years ago. It just went to trial. I just was last week in depositions in the Bronx, and the incident happened in 7 years ago, and we're just getting to depositions, right? So if people think lawsuits are fast, they are not. And they, both on the plaintiff, defendant, the witnesses, these are horrible. They go on forever, but sometimes you end up with almost $4 million to split between 5 of you and your attorney, who probably gets a third here. Or maybe there's a separate fee for the attorney, right? Like under an FLSA type thing. I didn't see that either way, but in any event, the point I took away from this as an aside was just, boy, this stuff takes a long time to get resolved, and it does.
The wheels of justice turn slowly.
They do, and
especially
you can delay stuff. Yeah. So, okay, that's our great show. That's our show. I hope people are enjoying this, and we'll tell your friends to subscribe, and let's get us up to 1,000 subscribers. That would be pretty cool.
That's really our next goal. So, I mean, if you can help us out, please click like. Assuming that you like what you hear, please click like. Please subscribe, and please help us grow. We'd love to keep doing this. Okay, absolutely. And that's going to do it for another edition of Fire Law Roundup.